Hey guys, let's talk about serving protective orders at residences. My name is Anthony Bandiero, attorney and senior legal instructor for Blue to Gold Law Enforcement Training. Bringing a roadside chat from beautiful Anaheim, California. We're actually at the National Interdiction Conference where I'm speaking today and tomorrow. Thank you, Desert Snow, for the invite and everybody here supporting us at Blue to Gold. We also have a booth here, so if you're here at the NIC, please come by and say hello. This officer is from Utah, and he says, all right, we have a protective order, and with this protective order comes this emergency packet, and it can be served, we have to serve it on this respondent, and we have the petitioner. All right, so I can put my phone away because let me tell you kind of what the facts we're dealing with here. The petitioner, the person who got the protective order, is the son, and they got it against his parents who live in the house. Well, it must be an adult son, right? And so the court has ordered that the parent, this respondent, this adverse party, has to beat it, has to get out, has to stay away from the home by a certain number of feet. The question is, if we arrive at that house and the parent, the adverse party, right, the judge has already said you can't be there, does not want to come out of the house, how much force can we use? Can we kick the door in and so forth? All right, I want you to think about a few things, okay? First of all, I'm not teaching you about Utah state law because I'm not familiar with exactly what the state law, but I'm just going to teach you about some constitutional issues to think about. Number one is that protective order likely did not authorize entry into any particular house. It did not say that it's not like a search warrant. Most of them are not like search warrants. Maybe some are, but usually they're not. So the first thing is that order by that judge, did that judge sign off and order you to enter that home to pull those people, to pull that respondent out? If the answer is no, it's not a search warrant, so we have to get another way into the house. The second thing is, usually the way we serve these protective orders is with consent, right? Hey, we got some paper for you. Can we talk to you for a second? They come out, they get their protective order. Boom, at that point, it's been served, they're done. The next thing I want you to think about is exigency. Many times the victim wants to return to their home, and you got this person in there that is, a danger to that victim, and there may be some exigency to get that person out of the home right now, right? I can't tell you every single time that's the case, but I want you to think about, do you have exigency? The next thing I want you to think about, so we have consent, exigency, and the last one is a lack of standing. How does your state authorize serving that protective order? Do they allow a verbal service? In Nevada, the protective order can be served verbally, which means that once I tell you that you're the subject of the protective order, it's been served. Now also, I want to give you all the information and so forth, but if that person is like, I don't want to hear it, I want nothing to do with you, get out of my house, whatever, then sorry, it's already been served. And once it's been served, constitutionally, that person who is ordered out of the house by the judge lacks standing to contest your entry. Here's what I mean by this. You get consent from the victim to get this guy out. You knock on the door, he answers, you say, hey, can you come out? I'm not coming out. Well, look, you've been served. You have a protective order against you. It's valid. I have it right here. At that point, in Nevada, for example, boom, it's effective. Now, because they've been served, they cannot be in that house. So then the police can walk into the house and say, you're coming out with us. That's how I would do it in a state like Nevada that allows verbal service, right? And many states are probably going to be the same way. I want you to think about that. If you verbally serve somebody, then it's served, and then you get them out, and you can give them the piece of paper at that point. That's how I would handle that constitutionally, but don't forget to comply with state law and so forth. I hope this helped you get it right every single time. Again, I don't know specific state law stuff, so look it up on your own, but those are the constitutional issues. If you like what we're doing out here, like, subscribe, share with your friends. Until next time, my friends, you stay safe.